Okay, Crumbley trial watchers, tomorrow is the day that we've all been curious about for quite some time, and that is going to be the sentencing hearing for Jennifer and James Crumbley. And I'm going to discuss the sentencing memo, but before I do that, I'm going to talk a little bit more broadly about how, as a criminal defense attorney, you and your client need to approach this hearing. So when you and your client prepare for sentencing, there's a couple of things that you need to do that are just universal. And one of those things is that you need to show an attitude that accepts the jury's verdict and respects their decision. You do not need to come in your sentencing hearing and start arguing with a sentence that has already been rendered or a judgment that's already been rendered, because you've already lost that battle. So you can say that while you don't agree with the jury's verdict, you do need to respect it. The next kind of overlying theme that you need to have is that you do not want to appear as though you're trying to excuse the defendant's behavior, but that you are trying to explain how we landed in a place where your client might have done something bad or obviously criminal. This is not the time to continue defending yourself with regards to the allegations, because a trier of fact has already determined that you did whatever it was beyond a reasonable doubt. During the sentencing hearing, you are trying to give the person that's going to be rendering the sentence. In Texas, we do have jury sentencing, which they don't have in Michigan. You need to be trying to give them a better picture of who your client is. Yes, they have done some bad things, but here is a greater picture of who they are, either in terms of maybe their background that led them down a path of criminal conduct, or here are some good things that you don't know that may change your view of who you think my client is. When I was prosecutor in voir dire, we would always say, and in Texas we say voir dire, other places say voir dire. If you said voir dire here, people would not like it. Trial is a snapshot about a day in time, and punishment is the photo album that shows you the whole series of events. And when I say events, that means life events of the defendant, the events of the day. Punishment is designed to give you a much broader picture of everything. And lastly, you need to show remorse. You can disagree with a verdict and still have remorse for your actions, but that is something that you kind of have to be mindful of during the trial. And I'll talk more about that later. Now, let's just start with this up here. Shannon Smith has offered to allow Jennifer Crumbley to live in her house. Yes, that is as crazy as you think it is. This is not something you should ever do. Ever. And I think that's probably pretty obvious to anybody with a brain, but this is a request that is not going to do the defendant any favors, because it still shows the kind of delusion that was seen during the trial from both Jennifer Crumbley and her attorney. The prosecution in their memo calls this an insulting request, and I would agree. It's bizarre, it's pointless, and whenever you are approaching a sentencing hearing where you have a very broad range of punishment, what you don't need to do is come in acting like you think it's completely absurd that you might find yourself at the higher end of punishment. You need to say, I don't belong there and here is why, but you do not need to act as though you getting prison time is crazy, which to me is what this is saying. Now, I have seen a lot of critiques that basically are like, I can't believe Jennifer Crumbley and her attorney are asking for mercy. Well, to that I would say, what the heck else is she supposed to do? But what she certainly shouldn't be doing, and what Shannon Smith does in her sentencing memo, is focus on Jennifer Crumbley's suffering. Nobody wants to hear it. Nobody wants to hear how this crime has impacted her life, at least not in the way Shannon Smith is doing it. They are arguing that she should not be in jail anymore and should be on some kind of supervised release. Instead of putting it that way, what I would maybe do is say, my time in jail has impacted me, and I understand why what I did was wrong, and I have changed. Again, I think it's a mistake to not accept that you're going to go to prison for this if you're Jennifer Crumbley, but if you're going to ask for something ridiculous, come up with a better way to ask. You can say, her life is significantly different than it was before she got into the jail, and focus on those things. But instead talking about all the things that she lost, all that's going to do is make people angry. I do think Shannon Smith has a point when she says that, Jennifer Crumbley is not an ongoing threat to society. I do believe that is true. But the thing that you're leaving out when you talk about it that way is that sentencing is not just about rehabilitation. It is also about punishment. And this is a situation where multiple people lost their lives. You always have to walk a line between asking for leniency and trying to indicate that you've already been punished enough. Shannon Smith also goes on to say that the prosecution stating that her not being at home was part of her liability is a sexist and misogynistic attack. I mean, what is she doing here? When the reason that you have liability is part of that is because you weren't doing your job as a parent, to go on to say that saying I wasn't doing my job as a parent is misogynistic is actually a really insulting argument to most people. She also continues to make this argument that failed at trial, saying that any parent could have made the mistake that Jennifer Crumbley did. Like, you tried that argument, it lost, you need to walk away from it. Remember how earlier I said that you need to respect the jury's verdict? Well, when you continue to make these kinds of arguments, you're showing that you don't have any respect for the jury's verdict. When you put on a defense, especially a defense that includes your client testifying, you always have to be mindful of the fact that you may have a punishment hearing coming up, and you need to balance how you approach your defense with the idea that at some point your testimony during the guilt-innocence phase of the trial could be used against you in the punishment phase of the trial, which is exactly what is happening here. This is why Jennifer Crumbley's answer to would you do anything differently is going to be so problematic for her. And that's exactly what the prosecutor is arguing in her sentencing memo. What Jennifer states in her pre-sentence interview is what she should have said at trial, which is, at the time, I didn't have the knowledge to do something different, but now I would do things differently. But unfortunately, if you've testified at your trial and said something contradictory to that, you are stuck with those words. Basically, what I'm saying is, if you are going to put on a defense and that defense includes testimony, then you need to leave room in your defense for you to later come back and appear remorseful. And that's why, in theory, James Crumbley should have been in a better position during sentencing, because he didn't testify and make a bunch of statements that he's now stuck with. But instead of just keeping his mouth shut like he did at the trial while he was in jail, he was on the phone making calls and making threats toward the prosecutor in this case. And besides his conduct here, that is what's really going to screw him, because it shows how little remorse he has, how little respect he has for the system. And instead of talking about himself, he's talking about the prosecutor, and makes himself look like exactly the monster that the state made him out to be during the trial. So what do I think is going to happen here? Michigan is very different than the state I practice in, but I would imagine that both of them are going to find themselves at the high end of the punishment range. And of course, that has to do with their conduct, but it also has to do with the fact that there's a lot of pressure on this judge to send a message with her sentence in a way that is not always at play, because there is so much publicity on this trial. Ultimately, I think the failing of Shannon Smith, and to some extent James's attorney here, is that when you go into sentencing, now is not the time to indulge all of your client's delusional ideas. It is your job to say, hey, we are in a bad situation. You need to prepare yourself for the worst, and you need to present yourself and your side in a way that looks like you understand that that could happen, and not continue to make the same deluded arguments that specifically Shannon Smith made at trial. I do think James Crumbley's attorney did a much better job at trial, but she's hamstrung by the things that her client has done outside of the context of the trial. House arrest is not going to happen. I mean, ultimately, I think these two are looking at probably 15 years in jail. These sentences will run concurrently because they have multiple counts, or at least I assume that they will. So all of their sentences for each thing that they were found guilty of will run at the same time. So anyway, once we get the verdict, if there's something I think I have to say, I'll come back and talk about it, because this trial has been a lot of fun to talk about.